All right, good afternoon, everyone. I'm Judge Jackie Powell, and we are in first appearance court. I am going to let you know if I've determined probable cause, and we will also talk about release conditions. Today's not your trial date, so I encourage you not to talk about your case on the record because everything in this courtroom is being recorded and can be used against you at a later time. If you are represented by the attorneys from the Public Defender's Office, I encourage you to speak with them before saying anything on the record. And if you are represented by private counsel, they normally come to the courtroom and are able to address the court on your behalf. We will begin this afternoon with Yolanda Cruz. We have Ms. Cruz. Okay. All right, Ms. Cruz, you are before the court for two municipal ordinance violations, and the court finds probable cause. Ms. Cruz, do you know what you want to do this afternoon? Oh, can someone turn on her mic? Thanks. Ms. Cruz, what do you want to do?
Yeah? Yes, I don't know what I'm here for.
Okay. All right. I don't. I don't know that Mr. Shate is gonna be here this afternoon. Miss Cruz, you're before the court for panhandling.
Okay.
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 So, what do you want to do with your case today?
I want to serve it.
Okay. Do you know what plea you want to enter? Guilty or no contest?
No contest.
All right. And so I accept your no contest plea and sentence you to adjudication and time served. Okay?
What thing over there? Huh?
You're all done,
All
ma'am.
over?
Yes. Okay.
Yes?
She's all done. Adjudication and time served.
Okay.
Andrea Yakiman Rouge.
She's at Paul Ryan, but they might not have gotten her there yet. She was scheduled for arraignment this morning.
Okay.
Your Honor, I can advise the court. Well, I don't know if you want to find out from the deputy first.
Is Andrea Yakiman back?
That's not her.
No. Andrea Yakiman. I'm sorry?
Did you call Miss Little? Natasha Little?
No. Andrea Yakiman.
Okay.
Is she there?
For Paul Ryan?
Yes.
Yes.
No, she's not here right now. Hold on one second. Let me locate her. I didn't have her on my docket.
Okay.
It's the same dockets, right?
The full name is Andrea Yakiman, Rogge.
While she's checking her, she's represented by Jonathan Freeman. I spoke to him before court,
Yes.
and we're on the same page. So just to let you know.
Okay. All right. When Paul Ryan, when you have Miss Yakiman Rouge, you can let me know. Tammy Lewis.
Yeah.
Okay. All right, Ms. Lewis, you're before the court on fraud, uttering false instrument, and count two is felony violation of probation, which has a no bond hold. And you go before your felony division judge tomorrow at 8:30.
Just 1 second.
I find probable cause, and your
Okay,
bond
great,
on
thanks.
count one is $1,000. Good luck, ma'am. Venice Authors.
She's here present, Judge Amain.
Okay. All right, Ms. Authors, you're before the court. Charge number one is driving with suspended or revoked license. Count two is temporary tag, 7 days or less. Temporary tag expired. And charge number three is felony violation of probation on a grand theft charge. That has a no bond hold. You'll be before your division judge tomorrow at 8:30. I find probable cause. Your bond on count one is $25. Good luck. Frederick Lewis. All right, Mr. Lewis is before the court. Charge number one is felony battery, domestic. Count two is violation of felony probation, which has a no bond hold, and you will be before your felony judge tomorrow at 8:30. The court finds probable cause, and I'll hear from the parties in setting the bond on count one. Good afternoon, ma'am. Okay,
Yes, Your Honor, I'm going to be requesting a $10,000 bond, no victim contact on count one. Considering he was on probation at the time of this incident, the level of violence, he was, he was arrested,
I'm sorry. What was he on probation for?
he's on probation for grand theft, I'm just referring to count two. It's
Okay.
a grand theft. He was placed on 18 months probation January 24th of this year. He was arrested for battery in 2017 against a different alleged victim that was dropped. He had another grand theft in 2015 that he violated probation on. Grand theft 2014 VOP, grand theft 2010 VOP, 18 months state prison. 07 burglary of a structure with a VOP, 18 months state prison.
Okay. Ma'am, who are you?
Stevan Martin.
Okay, and so, do you wish to say something in court today?
Yes, I wanted to.
Okay, hold on just a
Okay.
moment. You are the alleged victim in this case?
Yes.
And you gave a statement to the police, because I have a police report here that states what you said to them. I don't represent, you don't have an attorney representing you here today, and I cannot give you legal advice. But just so you know, it goes for everyone. Anything you say in this courtroom can be used against you at a later time. Okay? All right, so what do you want to say?
I just wanted to say that I didn't want to file charges against him.
All right, let me put you under oath. I'm gonna ask you to raise your right hand. Do you swear or affirm to tell the truth?
Yes,
Then you can put your hand down and state your name for the record,
Stevan Martin.
okay? And then go ahead,
I'm-
bearing in mind what I said to you before,
Yes, ma'am.
okay? All right, you can go ahead.
I wanted to let the court know that I didn't want to press charges and that I'm not in fear of my life of him, and I was coming here today to sign a waiver of prosecution.
Okay,
Judge, and speaking of Mr. Lewis, I did advise him in reference to count two, there's a VOP no bond hold. This court cannot do anything for him. He's gonna have to appear before his assigned judge to seek some sort of relief. in order to be released on that count. At this time, having heard from the alleged victim that basically she's not in fear, my understanding the date of incident occurred back in March 7th, 2019, or earlier this year. Judge, I know Mr. Lewis signed up for the public defender's office. Most likely, public defenders is probably going to contact the case filer. But at this time, I understand the court is bound by what's on the PC affidavit. So I'm going to be requesting a $5,000 bond on Mr. Lewis's behalf on count one, Judge.
Your Honor, and I just want to advise the court, I reviewed Ms. Martin's sworn statement that she gave law enforcement on March 7th. She was specifically asked, do you think he is capable of killing you? Her answer, yes. Okay, is there a prior history of domestic violence? Answer, yes. Question, when was that? Answer, a few times. A lot of times. Question, a lot of times. When was the most recent other than this evening? Back in like this time last year.
Okay. All right. Mr. Lewis does have a no bond hold, which this court can do. He has to go before his felony division judge. Based on the allegations in the probable cause affidavit, I am going to impose a $10,000 bond. No victim contact until further order of the court. Okay? All right, ma'am. Thank you. Paul Ryan, do we locate Miss Yakima Rouge?
Yes, I think we did, Judge. Or
Okay.
did
Are
we?
you on the phone with her, or?
She was in the unit speaking with medical at the moment, Your Honor. So I'm waiting on her to finish with that.
Okay.
Okay.
All right, do we have Vicky Alexis on page 5?
Yes, Judge, he's here at Maine.
He is a private
And
attorney.
Oh, there he is. Private attorney, sorry.
Good afternoon, Mr. Grossman.
Afternoon, Judge.
Mr. Alexis is before the court for aggravated battery causing bodily harm. Counts 2 and 3 are aggravated assault with a deadly, count 2 is aggravated assault with a deadly weapon without intent to kill. Count 3 is aggravated assault with a deadly weapon, domestic. Count 4 is petty theft. All right, the court finds probable cause.
Your Honor, I'm going to be requesting a bond limit of $5,000 per count on counts 1 through 3. Mr. Alexis has priors, but they consist, from what I can tell, of traffic priors, so that's really
Okay,
not aggravating. Obviously, I'd be asking for no victim contact, and if you could, if the court be inclined to specify to Mr. Alexis that no possession of any firearms or weapons is a standard condition of a domestic violence no contact order, please.
okay.
Judge, my client doesn't own any firearms. The alleged victims that were both on scene, one says that there was no firearm at all. So I don't think that's a concern at this point. He
Okay,
doesn't have one,
okay,
never had one. They have children in common, one of the victims and my client. So the money that he earns, because he has a full-time job, he pays support for those kids. We'd ask for lower bonds since I'd like to have him be able to put all his money towards the kids. That's the most important thing for him.
all right. All right, count 1, I'm gonna impose a $5,000 bond. And then counts 2 and 3, it'll be $2,500 each. On each count, no victim contact and no possession of firearms or weapons, which should be no problem if he has none. Okay. All right, sir, good luck.
Thank you, Judge.
Thank you, Mr.
Judge, I have Ms. Jacobin here.
All right, Jerome,
No, I think they said they have her.
oh, they're saying Miss Rouge is there?
Yes.
Okay,
Ms. Jacobin.
all right, thank you.
You're welcome. Thank you.
All right, Andrea Yakiman, you're before the court. It's an additional charge for carjacking with a firearm or weapon.
Your Honor, Ms. Yakima Roger was scheduled for arraignment before Judge Shearer this morning.
Okay,
Mr. Friedman had filed a waiver of appearance. I spoke to the prosecutor on the case. What I was advised is that Judge Shearer ordered her to be, at this time, held no bond on the carjacking. She scheduled a status for the 13th, which is when she's also being held no bond on a drug case.
okay,
That's up for calendar call on the 13th. Judge Shearer's just trying to keep all the cases together. I spoke to Mr. Friedman. I brought it to his attention that both cases are going to be up for the 13th. He wanted me to just mention to the court, he's aware. He will file, the appropriate motions or take any matters up before Judge Shearer on the 13th that he believes appropriate at that time.
okay. All right, so ma'am, at this time, whatever conditions your division judge has ordered based on the arraignment, it's a no bond hold? Is that correct?
My understanding is that she ordered, she was advised that it's a PBL, that there was a no bond. She said, keep the no bond, we'll deal with it on the 13th.
All right, so we'll keep the no bond hold until you appear again before Judge Shearer, okay?
Okay,
All right, good luck.
thank you.
You're welcome. Jerome Holmes?
Judge, if you called Mr. Holmes, he bonded.
Okay, thank you. Chadrick Spence?
Yeah. Mr. Spence, Judge, he's here at Maine. Come on up, sir.
Mr. Spence, you're before the court this afternoon for one count of resisting officer without violence. Count two is a traffic infraction that's not for magistrate. The court does find probable cause. What does Mr. Spence wish to do?
Judge, and speaking Mr. Spence, he wishes to resolve this case today.
Okay.
One moment, Judge. Your Honor, I don't have an offer. It appears that Judge Diaz, Mr. Spence has an open 2017 disorderly conduct, resisting without violence and trespass. In February, I guess Judge Diaz signed an order appointing experts to determine competency.
Okay.
As I don't know that that's been determined at this point one way or the other, but as best I can tell, Mr. Spence had a status conference before Judge Diaz yesterday where a defense motion for a continuance was granted.
Okay.
And then this morning, he got
All
arrested
right.
for this.
So then, based on that information, yes?
Judge, yes, I understand why the state doesn't have a plea offer, but in speaking to Mr. Spence, Judge, he does have a place where to live. It would be an apartment with his brother who he lives with. He did receive disability. He told me there was an interruption in services, and he's trying to get that reestablished. Having said that, Judge, would you, considering this is a nonviolent offense, would you consider releasing him ROR on pretrial release?
And Your Honor,
No, I'm not gonna grant that, so, obviously, there are prior issues, and, if there are, pending issues to be resolved at this time, I think the most prudent thing for me to do is to leave the bond in place at $100, and then they'll determine whatever other issues that need to be determined, okay? Deidrean Parkinson?
Mr. Parkinson is present, Judge, here at Maine. Come on up, sir. He's approaching, Judge.
All right, Mr. Parkinson, you're before the court. Count one is a municipal ordinance violation for possession of marijuana. And then count two is a misdemeanor KPS on a operating without valid license charge. And the court finds probable cause. This is a KPS from 2017, okay?
I see that. It's a pretty old charge, Judge. I'm gonna ask the court if the court would have, would consider releasing Mr. Parkinson ROR. If not, in the alternative, Judge, I'll ask you to sign a phone order so he can have access to his contact number so he can contact his friends to post his monetary bond.
I'd ask that the court keep the capias in place. I understand, when we're dealing with capiases that are 6, 7, 8 years old, but a capias from 2017 really isn't that old.
And what kind of priors, what, does he have a criminal history?
One moment, I'd have to check.
Okay.
Not showing anything, Judge.
All right. I'm gonna release Mr. Parkinson to pretrial supervision. It's gonna include random drug testing. Sir, you need to report to the pretrial office within 24 hours of your release. Failure to do so, a warrant will be issued for your arrest. Do you understand that, sir?
Yes, ma'am.
All right, good luck. Yes, yes. All right, Michael Danahan.
He's approaching, Judge.
Mr. Danahan is before the court. Count one is assault. Count two is disorderly intoxication. The court finds probable cause.
Your Honor, the state's going to be requesting a bond increase on count one to $500. His criminal history includes a battery in 2014, grand theft 2013, theft 2014, resisting with violence and battery on a law enforcement officer 08, DUI 08. Nothing further, Judge.
Okay.
Judge, I did discuss, the standard bond, which was already placed as far as $100. And Mr. Denham advised me that he's not in a financial position to post that, let alone what the state is suggesting as far as $500. My understanding, Judge, he's been residing here in our community his whole entire life. He's self-employed. He pressure cleans for a living. He's been doing that for about 3 years, supporting himself. And right now, he advised me he has a newborn baby. He's a father, and whatever finances he has goes towards supporting his child, Judge. He lives in Cooper City in a duplex where he's been renting out for 2 years. And Judge, from what he advised me, after pays rent, pays the bills, goes ahead and supports a newborn infant, there's really nothing he has, not even $100 to post. So, Judge, considering this is, I believe, a misdemeanor, I'm asking the court that the court would consider releasing Mr. Denham on pretrial release so he can be supervised.
All right, well, with the level of, the level of the threat, even in front of a police officer, I'll release him to pretrial, but he'll be on a level 2 GPS.
Yes, Judge, thank you.
All right. Matthew Thomas,
Mr. Thomas, come on up, please.
Mr. Thomas is before the court. Count 1 is grand theft auto. Count 2 is operating without a valid driver's license. Count 3 is a traffic capias. The court finds probable cause.
Your Honor.
Yes.
Assuming the court takes no additional action, the state is going to be requesting a $5,000 bond, pretrial release of the GPS. That being said, Mr. Thomas is out on bond right now. He's out on a total of $8,700. He was arrested May 16th for felony battery, domestic violence, misdemeanor battery, domestic violence, 2 counts of criminal mischief, and tampering in a third-degree felony proceeding. He was bonded out and released May 18th. I spoke to his bondsman, Mr. James Jones, this afternoon. He wanted to advise me. His family is very concerned about him. They have fear that since he's gotten out, he's been continuing drug use. And they're very concerned about him coming home.
That case, this May 18th, is it a filed case?
No, it was just I don't think so, because it was just 2 weeks ago, but
Okay.
I can check.
What is the case number?
One moment. No, a final decision hasn't been made yet, but it is 196304 CF10A.
Okay. And aside from that case, are there any other priors?
I'd have to check, Your Honor.
Okay.
Okay, from what I can tell, he was arrested April 11th of this year on a failure to appear. That was on a traffic matter. I can also advise the court. He's 19. As a juvenile, he has had arrests for several serious violent felony offenses, but they were dropped. But I can also tell you, between the years 2016 and 2018, numerous pickup orders were issued based on failures to appear.
Okay.
Judge, bottom line, on this felony arrest, basically, he has no prior convictions for any felony offense. So basically, Mr. Thomas does have a clean record. Now, I believe the driving or traffic offense that the state was referencing, I believe this is the same count on count 3. Having said that, Judge, right now he is working. He works for a moving company. He's been employed there for about 3 years, making approximately $100 a day. Now, he lives in Lauderdale Lakes in an apartment by himself. He's a foster child through ChildNet. He receives certain services. My understanding, Judge, I understand that he's out on the case. My understanding he's out on a straight bond. I'm asking if the court is inclined to take any action to consider at this time placing Mr. Thomas on pretrial release. He'll be able to be supervised. He'll call in, report in. And Judge, considering what's before the court is nonviolent in nature, I believe it's a reasonable request. So that's what the defense is asking for at this time.
Your Honor, I don't know how realistic it is to believe that Mr. Thomas is going to comply with pretrial. Mr. Romero just mentioned, the arrested April on the capias was the same case that he's here on the KPS before. He had to pay a $250 bond for not going to court. That didn't keep him from missing court again on the same case, and now with the $500 bond.
Well, based on what I've heard, this is May 18th. It's less than a month ago that he posted bond. Plus, he's before the court on a KPS that is a second KPS after he was KPS and received the bond. So at this time, on case number 196304 CF10A, at this time, I am going to revoke the bond. On that case, and he'll be held no bond until he goes before his division judge. As to this new arrest, on count one, he's gonna have a $5,000 bond. All right, and he has a $500 bond from the KPS on the other judge. All right, Alan Vlado. Okay, thank you. Breon Kinder.
Mr. Kinder, come on up, please.
And, Your Honor, Mr. Kinder's represented by Andrew Smallman.
Okay,
He had asked, I spoke with him this morning, he'd asked if the court would be inclined to, if he could appear telephonically.
okay.
Do
Do you have his number?
Yeah, I'll write it down for Your Honor.
Okay.
Andrew Smallman.
Good afternoon, Mr. Smallman. This is Judge Jackie Powell.
Hi, how are you?
I am well. We're in open court and you're on speakerphone. And so I have your client, Breon Kinder, before the court this afternoon.
Yes.
All right.
My understanding, he's held no bond on the VOP, correct?
That's correct.
Okay. Well, no use arguing for bond on the other ones, if he's going to be stuck. Do you have a VOP date that he's going to be in front of his judge?
It looks like tomorrow he'll be before his division judge.
Okay. I will put it on my calendar to be there for him.
And Your Honor, just to verify, because I spoke with Mr. Smallman earlier and I went through the probable cause affidavit. My understanding is on the third page of your report, there should be a handwritten note that Detective Bates initialed stating
There
that the
is.
drugs were field tested.
Yes.
Okay, I just wanted to verify for the record.
Okay. All right. Okay, so then, finding probable cause, then I'll leave the standard bonds in place. And he has court tomorrow, before his division judge at 8:30, okay?
Thank you,
Okay.
Judge.
Just let him know. I'll see him then.
All right, sir.
Thank you. Have a great day.
You too. Bye. You'll see your attorney in court tomorrow, Mr. Kinder, okay? Troy Tigner.
Come on up, sir. Judge, Mr. Stigner is here. He's approaching, and he declined the services of the public defender.
All right, Mr. Tigner, are you hiring private counsel?
Say that again?
Are you going to hire a private attorney?
Yes.
All right. You are before the court this afternoon for one count of grand theft. And the court finds probable cause. Does the state wish to be heard as to bond?
No, Your Honor, Mr. Tigner has no criminal history, but considering the alleged amount of stolen, the value, I think $1,000 is reasonable.
All right, so your bond, sir, is $1,000.
Thank you.
Michael Jones,
Michael Jones? Come on up, sir. Mr. Jones is approaching, Judge.
All right, Mr. Jones is before the court for one count. Mr. Jones, please. Mr. Jones, I need you to listen to me, sir.
You on?
No, you need to listen to me first, okay?
Okay, I'm gonna listen to you.
You are before the court this afternoon for one count of possession of PVP. Count 2 is resisting officer without violence. Counts 3 and 4 are felony cases, and those have no bond holds and are not from magistrate. So you have 2 no bond holds, and you have court tomorrow before your felony division judge at 8:30. I find probable cause. Okay, so.
Some of my hearing, man. I'm trying to understand it because I was out on bond, and the bail's foreman called me to his office, and I took an affidavit down here for my public defender.
Judge,
Let
may I
me
have
know
one
All
moment,
right,
please?
all right, Mr. Jones's bond on count 1 is $1,000, and he has no bond holds on the other counts. He'll be before his division judge tomorrow. Rashad Gator. Mr. Gator
Judge, I've been
bonded.
advised Mr. Gator bonded.
Thank you. Dayton Madison.
He's approaching, Judge. And Judge, Mr. Madison declined the service of public defender.
All right. Mr. Madison, are you hiring private counsel? All right, well, you're before the court this afternoon for one count of grand theft. And the court finds probable cause. Does the state wish to be heard?
No, Your Honor, the only thing I'd request is an order of no victim contact.
All right, Mr. Madison, you have $1,000 bond, no victim contact. That means you cannot be in touch.
Can you repeat that?
All right, okay. So, you have $1,000 bond on the grand theft charge. I'm ordering no victim contact, and I'm also ordering no return to that location. Do you understand that, sir? Okay, good luck. James Procaro.
Did you see? Judge, Mr. Picaro bonded.
Okay. Earl Brewer.
Mr. Brewer is here present and approaching. Come on up, Mr. Brewer.
All right, Mr. Brewer is before the court for one count of burglary with assault or battery. And the court finds probable cause.
Your Honor, the state is going to be seeking a finding of proof evident or presumption great and request that Mr. Brewer be held no bond for first appearance purposes only. It's a filed case, and I'm also making this request based on the level of violence, the injury that was suffered by the victim. I'm relying upon the probable cause affidavit. If the court should finds proof evident or presumption great, but chooses to exercise your discretion in setting a bond, or does not find proof evident or presumption great, I would ask if I could have a brief moment to argue for bond in that matter.
Okay.
And we would object to the court making a finding of proof evident presumption great at this stage of the proceedings, Your Honor. All that's been presented to the court at this point in time is an affidavit, which is insufficient, in our opinion, to establish the highest burden of proof that we have in the criminal justice system. The state having called no witnesses, introduced no evidence, no photographs of any injuries, nothing along those lines whatsoever, relying instead on a report written by an officer who did not witness these events. I feel that that burden has not been met, and I would ask you to set a bond for Mr. Brewer if the court is not inclined to set a bond for Mr. Brewer or finds over our objection that proof evident is and presumption great has been established, then we would ask the court to exercise its discretion and set bond for Mr. Brewer.
All right, based on the allegations in this probable cause affidavit, I find probable cause. I am going to make also a preliminary finding of proof evident presumption great. The allegations that are here creates cause for concern for the community. The allegations, someone was delivering food from a restaurant and was beaten. And so the court finds probable cause and making a further finding, preliminary finding of proof evident presumption great. Mr. Brewer will be held no bond. This is without prejudice for him to file a bond hearing based on State v. Arthur.
And Judge, speaking of Mr. Brewer, he wishes to address the court. I did advise him not to talk about the facts of the case, but he wishes to address the court.
Okay?
Good morning, Your Honor. Your Honor, my constitutional right, man, my due process, man, this gentleman right here, man, did make a valid point, and you said, a concern, man, for the safety of the public, if it was a delivery. I have no knowledge of these incidents even occurred, and there's a police report made, that means I had to be present too. And if I wasn't arrested right then and there, when I took my statement, how can these allegations come about later on down the line? That's all I'm saying, Your Honor.
Okay.
Because that is my due process.
Then that's what you will discuss with your attorney in creating a defense for these purposes of first appearance. I've made.
Yeah, this is a first appearance, but it's a preliminary hearing too. And it was in your realm and your jurisdiction, Your Honor, because a police report was made. I also was present when the police report was made. If I wasn't arrested then, how can I be arrested now for these allegations? Because I'm supposed to went in right then and there. This happened at the address that is listed under my address of residence.
Sir,
So there's no way that this can be a presumption of guilt. That's great, Your Honor. That's all I'm saying.
okay, all right, well, I disagree with you, so you'll have a hearing before your division judge, okay? Sean Merriman,
Mr. Mayor?
all right, Mr. Merriman is before the court for grand theft auto. And the court finds probable cause.
Judge, and speaking of Mr. Merriman, I did advise him that the standard bond which is in place is $1,000. He advised me he cannot afford that at this time. He's been residing in our community for over 30 years. He's 42 years old. He works for a labor pool. He lives here locally in Fort Lauderdale with his mother. He's been residing there for the past 3 years. I apologize, 3 years. So, Judge, at this time on this non-violent offense, I'm asking if the court would consider releasing him on pretrial release.
Okay. Does Mr. Merriman have a criminal history?
Does, Your Honor.
Okay, so I'll release Mr. Merriman to pretrial supervision. Sir, you need to make sure that you report to pretrial within 24 hours of your release. If you don't report, a warrant will be issued for your arrest. Do you understand that, sir?
Yes, ma'am.
All right, good luck. All right. And do we have Mr. Stinson this afternoon?
No, Your Honor, he's
Okay.
still.
All right, let's go to the hearing dockets. All right. On the misdemeanor hearing docket, Yusuf Hedrington,
I believe.
okay? That's Yusuf Hedrington. Hedrington.
James?
He was arrested on May 28th, and he has, well, sir, did you resolve your violation of probation matter?
Yes, ma'am.
And what happened there?
I got reinstated.
Okay,
As far as I can tell, Judge, this is the only thing holding him right now with a $100 bond.
okay.
You want to try and resolve this today, Mr. Hedrington?
Yes, sir.
One moment, Judge. Offer be time served.
Okay. So, do you wish to resolve the case?
Yes, ma'am.
And you heard that the offer is adjudication and time served. Do you want to accept that?
Yes, ma'am.
All right, then please raise your right hand. Do you swear or affirm to tell the truth?
Yes, ma'am.
You can put your hand down. Mr. Hedrington, do you understand everything that's going on here today?
Yes, ma'am.
Is anyone forcing you to resolve your case?
No, ma'am.
Are you under the influence of drugs or alcohol?
No, ma'am.
Do you need any more time to speak with your attorney?
No, ma'am.
And sir, you understand that you do have the right to go to trial, but by taking a plea today, you are giving up that right?
Yes, ma'am.
And have you ever been treated for mental or emotional illness?
No, ma'am.
And sir, do you understand that if you are not a U.S. citizen, that by taking a plea today, it could subject you to deportation or immigration changes?
Yes, ma'am.
What plea do you wish to enter? Guilty or
No contest.
Okay, I accept your no contest plea. Find that it's freely and voluntarily given. Your sentence, sir, is adjudication and time served. Good luck.
Thank you.
Always. I cannot waive court costs. All right, Brian Jaquette.
North Broward.
I'll give him 6 months on the court costs. Okay. All right, Mr. Jaquette was arrested, it looks like May 11th, is that correct?
Yes, ma'am.
Yeah, the only thing holding him, it's a criminal mischief where his bond was increased to $1,000.
Is it on this? Because this,
Yeah, that's this
this doesn't
case.
even show that, what the charge is.
I know,
Okay.
yeah.
So
Oh,
the
Your Honor,
only
'cause-
thing holding him is this criminal mischief?
yeah, Your Honor.
Yes.
Yeah, the reason is, I think it's not showing the charges.
Uh-huh,
When he was arrested, he was charged with burglary of a dwelling, criminal mischief, and trespass.
okay.
The burglary and trespass were dropped. The criminal mischief was filed, so it created a new misdemeanor case number.
Okay.
I can't make an offer at this time because the allegation is he damaged property in the dwelling.
Yeah, I see that on the,
Okay, you have it, okay.
all right.
Let's see, what's,
That's not true. For the damaged property,
All right, I'll just tell you not to talk about your case because you may not be able to resolve it here today. If there is restitution to be paid, you cannot resolve the case at first appearance, so you may not want to talk about your case.
the only other thing I see, Your Honor, when he was arrested on these new charges, he had an active capias for unlawful use of false name ID from 2018, but he has pled that out since.
Okay? So
Yeah.
whatever else he was pled out,
It looks that way, Judge. In all honesty, I wasn't able to get a lot of information out of Mr. Jacquet. There's really not much I can tell you about him, other than that he can't make a $1,000 bond. But I don't know where he would go or where he would live or if his,
sir, do you have a permanent address?
yes, ma'am.
What is that address?
16550 Northwest 20th Street.
And who lives there? Who else lives there?
My brothers and my mother.
And are you employed? Or were you employed before you were in custody?
Yes, ma'am.
And are you able to go back to that job?
Yes, ma'am.
What is the place? Where is the place that you were working?
It was a restaurant, ma'am.
What is the name of it?
A pizza restaurant, Little Caesars.
A what?
Little Caesars, a pizza restaurant.
Where is it located?
It's located on Dykes Road.
Okay. Well, his booking report shows that he's at large.
Your Honor, I apologize. What address did he give again that he resides at?
You want to say the address again where you live?
Thank you, Judge.
What's the address again?
20th Street, ma'am. 16550.
See, and it looks like right next door to where this happened, and I don't know if you already saw, Your Honor, I guess law enforcement was able to speak to his mother. It's at the very bottom of that, yeah. I mean, I'd be okay with setting, and this obviously wasn't a consideration then because it had a felony charge. Let me show Mr. Brian, do you have the copy of the PC there?
No, I was looking at the Little Caesars on Dykes Road, and there is one.
Let me show you something. Brian?
Yeah.
Because my thought is, Your Honor, now this case would be eligible to send to Judge Lerner Wren.
That's what I figured.
All right.
I think the case would be appropriate, based on my conversations with Mr. Jacquette and the
Right.
probable cause
That's what I was
affidavit.
trying to figure out what's going on. So I'll sign the order to transfer it to Judge Lerner Wren.
I'll let her judicial assistant
Okay.
know, Judge.
All right, Mr. Jacquet, you'll see your division judge shortly, okay?
Okay,
All right, good luck, sir.
thank you.
Oscar Quinteros.
Judge, he's approaching you, hearing me.
All right, Mr. Quinteros was arrested on May 31st. And so he's back for a second look at his bond status. How much bond is this?
Correct. I think he has a total of $300, Judge. My understanding and speaking to Mr. Contreras, I did advise him what the charges are: disorderly conduct, disorderly intoxication, resisting without violence. Judge, he's going to be asking if the court will consider resolving these matters today.
One moment, Judge.
Okay.
Your Honor, if Mr. Quinteros wants to resolve the case, the offer from the state would be 10 days county jail credit for time served. Looks like he's got an open trespassing at another location. He pled out another trespass. May 9th in first appearance. Trespass in 2018 with a violation of probation in January of this year. 2017, robbery with a firearm or deadly weapon. 2013, robbery with a firearm or deadly weapon. 4-year state prison as a habitual offender. Trespass 2012, failure to leave property 2012. Battery, felony due to priors 2011, 4-year state prison. Goes on from there.
Okay.
Judge he wishes to accept the state's offer.
All right, Mr. Quinteros, please raise your right hand, sir. Do you swear or affirm to tell the truth?
Yes, ma'am.
Okay, sir, you can put your hand down. Mr. Quinteros, do you understand everything that's going on here today?
Yes, ma'am.
Is anyone forcing you to resolve your case?
No, ma'am.
Are you under the influence of drugs or alcohol?
No, ma'am.
Do you need any more time to speak with your attorney?
No, ma'am.
And sir, do you understand that you have the right to go to trial, but by taking a plea today, you are giving up that right?
Yes, ma'am.
And sir, have you ever been treated for mental or emotional illness?
No, ma'am.
And sir, do you understand that if you are not a U.S. citizen, that by taking a plea today, it could subject you to deportation or immigration changes?
Yes, ma'am.
What plea do you wish to enter, Mr. Quinteros?
No contest.
I accept your no contest plea. I find that it's freely and voluntarily given. Your sentence, sir, is adjudication, 10 days in a Broward County jail with credit for any time you've already served. Good luck, sir. William Lewis. All right, Mr. Lewis was arrested on May 30th. Don't know. He's back for a second look
Yes,
on
ma'am.
his bond status. And how much bond does he have?
$100 on the theft.
Was there restitution?
Looks like the property was recovered. I mean, I don't know if they're going to be able to resell it, but
No, oh well. Mr. Lewis, what do you want? Is there something else holding you in custody, sir?
No.
Yeah, I don't see anything else, Judge.
All right, are you interested in resolving your case today?
Yes.
State, would you have an offer for Mr. Lewis?
the offer be time served, Your Honor.
All right.
No return to this.
Do you want to accept the time served sentence?
Yes.
All right, then please raise your right hand as best you can. Do you swear or affirm to tell the truth?
Yes.
You can put your hand down. Mr. Lewis, do you understand everything that's going on here today?
Yes.
Is anyone forcing you to resolve your case?
No.
Are you under the influence of drugs or alcohol?
No.
Do you need any more time to speak with an attorney?
No.
Have you ever been treated for mental or emotional illness?
No.
And sir, do you understand that if you are not a U.S. citizen, that by taking a plea today, it could subject you to deportation or immigration changes?
Yes.
What plea do you wish to enter, sir? Guilty or no contest? Guilty
No
or,
contest.
okay, I accept your no contest plea. I find that it's freely and voluntarily given. Your sentence is adjudication, time served. Sir, no return to that location. Do you understand that?
Yes.
All right, good luck, sir.
Thank you.
Alexandra Dominique,
Medical reset.
okay.
Your Honor, I mean, I don't know exactly how you might want to handle it, because Ms. Dominique was a medical reset this morning on her first appearance.
Right,
So now it's like we're going to be resetting her first appearance
well,
and
we're
her
not,
second look.
well, we're not resetting the second look.
Okay,
That's-
okay.
All right, I believe this lady's here on, Latasha Little, so can we
Yes,
call
Judge.
that?
That's correct, Your Honor.
All right, Judge.
All right. All right, so Miss Little was arrested on June 1st. So she's back for a second look on her bond status. How much bond? I think
It's
have it.
$1,000.
Yeah, it was,
She has $1,000 bond. Oh, this was from over the weekend.
yes, Judge. My concern is, it's alleged that she went to a neighbor's home and with a knife slashed 3 tires on each of these 2 vehicles in the neighbor's property. From what I can tell, I don't see any local priors. My concern really is that there be no ongoing issues between these neighbors.
Yeah, Miss Little and I did discuss, and she's anxious to have her day in court as well, Judge, but we did discuss the fact that she cannot have any contact with these individuals whatsoever, that if she sees them, she
I
has
don't
to
even
walk
know
the
who
other
the
way.
neighbors are.
All right,
Don't talk about the case at this point, Miss Little.
Okay.
Judge, she has lived here all of her life. She's been living in the same location for the last 19 years. She has 2 daughters, ages 21 and 22. They're both college students. She has a background in accounting, and from what I understand, she has no prior contact with the criminal justice system. I would ask the court to consider pretrial release for Miss Little. From my conversations with her mom, coming up with the monetary bond would be difficult for them to do.
good afternoon, ma'am.
Hello.
You're Miss Little's mother?
Yes, I am.
Okay, all right. And all right, I'll release Miss Little to pretrial supervision.
Your Honor, would the court consider a psychosocial evaluation? I have some concerns here, just,
I'm trying to figure out, there's something just seems off, but I don't know what it is,
that's why I thought,
based on the allegations in the police report.
and Your Honor, and that's why I thought if the evaluation shows nothing, then no harm, no foul. But if there is, then maybe there's some help that that Miss Little can get.
All right, I will release her to a pretrial and I'll order the psychosocial evaluation, okay? All right. Deputy, if you give Miss Little the information for the pretrial office, please?
Yes, I have it for her then.
I just want to see you hand it to her, please, so I can talk to her about it.
Okay.
All right, ma'am, the deputy has just handed you the information. It's the address for the pretrial supervision office. Within 24 hours of your release, that means by tomorrow morning, you need to go to the office to sign up. All right, they open at 9, so you can get there by 9 a.m. to sign up. If you don't go to sign up, a warrant will be issued for your arrest. Do you understand that?
I understand. Do they provide transportation? Because I don't have fuel and I don't own a car.
No, they don't provide transportation. So this is in lieu of you posting a bond, because your mother is here and there's indication that you cannot afford the bond. So you are going to have to find a way to get to the pretrial office in lieu of posting a bond,
Okay.
okay?
Your Honor, the only other thing,
I
only because
understand.
none of us were here this weekend, if you could please advise Miss Little just not to have any contact.
So, these police reports, and I'm not telling you to talk about the case, and I don't want you to tell me who you know or don't know. You'll have that time to speak with your attorney. But based on the allegations, it says that this incident occurred with the neighbor. So you are not to have any contact with the neighbors. Do you understand that?
With any neighbors?
Yes.
Okay,
Okay?
I understand.
All right. Okay. All right, good luck.
All right, good luck.
Okay.
Thanks, Brian Reedy.
I'm sorry?
You're welcome.
Thank you, Judge.
I'm gonna let you go. Give me like 2 minutes, okay?
All right, Brandon Hirsch. We'll go back to page 1 on the,
Sure.
Hirsch, he
I've
bonded?
been advised he's bonded.
All right. And then Jermaine, wasn't Jermaine Bragdon? Was he on the docket this morning? He was on, I saw him
docket
yesterday? I don't, all right, so Mr. Bragdon was arrested on May 1st.
Yes.
That's right.
yeah.
Okay, I was trying, I
Yeah.
know that his name was on the docket yesterday. All right.
Yes, Your Honor, the state still,
He was
you know,
gonna
just
go
like
to
we did yesterday,
court.
has not filed an information, so it's, I guess, his call where to go from
Let me
there.
give him a call and talk to him, Judge.
Okay, all right, Mr. Bragdon, your attorney's gonna call you. Have a, so, answer, allow him to answer the phone, okay? Corey Butts,
All right, Judge.
all right, Mr. Butts was arrested May 2nd.
Yes, Your Honor, the information was filed as presented, yesterday.
Okay, so, Mr. Butts, you were brought before the court for a motion for release. The state has now formally filed the charges, and so at this time, the motion for release will be denied, okay? Good luck, sir. You should be going before your division judge shortly for arraignment and other motions, okay?
Okay.
Gabriella Zater,
She's there,
All
Ryan.
right.
what's the status on Ms. Zater's case?
Your Honor, we may have to put this on recall. I can provide some information, but ultimately, Mr. Reedy may have to advise her. Basically, we have not filed an information. She
Okay.
has an out-of-county probation hold.
Okay,
I spoke about this matter with her early representation unit attorney
yes,
and the case filer. It's ultimately gonna be up to Ms. Zader whether she wants to accept the ROR or not. I just advised them that, Your Honor, the court and the parties involved would, at least inform her of all the potential consequences of her decisions. My understanding is while taking the ROR would, allow her to go up to Osceola County, since it is a VOP, I don't know that anything's gonna happen in Osceola County until these, local charges are resolved one way or another.
and the local charges are the basis for the VOP?
Exactly.
All right,
You know, I think there's multiple, because I'm seeing count 4 is an out-of-county hold, and then count 5 is a 94806. So I think there might have been a warrant to begin with, and then these additional charges.
okay.
Brian,
Mr. Reedy, are you familiar with Ms. Zader's?
Zader, I spoke with Austin, and basically, she's got the out-of-county VOP. Yes, she could take the ROR and go up there, but considering it's a VOP, they're not gonna do anything. Osceola's not gonna do anything until they know what's happening with the other.
Basically wanted to leave the decision up to you, Gabriella. I mean, it is possible that if you get released at this point, you might be going up there and coming back here and then going back up there. I mean, I think that was what Mr. Saunders' concern was.
Which, and stop getting game time locally here.
And stopping getting game time. As Mr. Saunders wrote to Mr. Cohen in the state attorney's office, it really is up to her. We can ask her when the motion is called. Usually we like to send them off to resolve their VOP first in other counties, which is true, and get them out of our jails. They may be willing to reinstate. her there or revoke, maybe a short jail sentence so she can come back out of custody. If you don't want to be transported and stay here, I can withdraw the motion.
And Brian, just so you and Ms. Zader is aware, the issue that Mr. Cohn was bringing up to Mr. Sanders is there is no guarantee that Osceola County will resolve a VOP when there are charges that are form part of the basis for the VOP still pending.
That's a possibility. That's a possibility. We
All right,
could,
Ms. Zader, do you understand what's being said?
Vaguely.
All right. So you are in custody on these charges, drug charges, 3 counts. And while you have this pending charge, you have a violation of probation matter in another county. The charges that are here in Broward are part of the violation of probation in Broward, in Osceola. So if, even though the state has not formally filed the charges and you are entitled to be released, if I sign the order releasing you, the first thing is gonna happen, you're going to stop getting credit on, for time served on this case. And 2, no one can guarantee that even if Osceola County comes and gets you, because these charges are part of the basis of the violation, they may not be able to resolve the VOP up there. So I guess the decision that you have to make is whether or not you want me at this time not to do anything with the 30-day motion and release you, and try and resolve these cases here and then go to Osceola. Otherwise, Osceola is gonna come get you only to find out that you haven't resolved the cases here and you still would have to come back to resolve the cases here. So that's where you are.
I don't.
All right, so what I'm gonna do
So
at
it's
this.
either. I'm sorry.
Go ahead.
So I could get the possibility of getting released now and Osceola coming to get me, or waiting here to finish these charges and then go to Osceola?
that's pretty much it.
Yes.
So if you get out now, you have to go back to Osceola.
Is that, yeah? So I get,
You get out right now,
if I get out right now,
I have to go back to Osceola.
I have to go back to Osceola on my own, or?
No,
No,
you're
they'll
not
come
gonna
and
get
get
out
you.
on your own. The Osceola is gonna, if I ROR you here, which means I've released you on your own cognizance, but then Osceola is gonna come get you. You're not gonna
Okay.
go out and have to find your way up to Osceola. They're gonna come and get you.
Okay.
So what does okay mean, though? I know it's a tough decision. Do you want me to grant the motion to ROR you?
Yes, ma'am.
All right, so I'll sign the order granting the ROR, okay? All right.
Good luck, Gabriella.
Thank you very much.
Dwayne Clark?
Judge, I've been informed by the deputy, I guess he was deleted?
He should have been, Your Honor, he should have been deleted on the misdemeanor. He was in the instructions from,
He was on the misdemeanor as well? It's not deleted on mine, so if he's deleted, that's fine.
I can just tell you, the instructions I saw from, trying to find that email that Ms. Monteith sent out, one moment. Yes.
What?
Yeah, you didn't mean this ordinance in a felony. I mean, Your Honor, I can advise you. It's whatever Your Honor wants to do. He does have a $50,000 warrant out of Monroe for eluding lascivious act.
Okay.
Somehow it's only pickup Monroe County only. I spoke to the Monroe County Sheriff's Office, but
Okay.
That's what I was planning on bringing to the court's attention when asking the court to take no action today.
Yes, Mr. Mayor?
If I heard that correctly, I believe, Mr. Lender, only one of them was supposed to be deleted, like the municipal ordinance?
Yes.
So if the felony still was supposed to be heard today, Judge, I would ask for it to be reset tomorrow.
But why is he not here today?
I believe there was confusion, Judge.
Okay.
Dwayne Clark.
All right, we reset till tomorrow. Beverly Thurston,
She's out of custody, Judge.
okay. And then, Afori Johnson,
He's approaching, Judge. Come on in, Mr. Johnson.
Mr. Johnson is before the court for, he was arrested
He
on
has a-
5/31, and, he has a $6,000 worth of bond.
Check homeless. He can't afford the $6,000. My understanding, Judge, is he's been here about 20 years, living in our community. He's 48. Now, this is what he advised me, Judge. The last time he's been in trouble was about 12 years ago. I understand these are two felony offenses, but if the court confirmed he's been out of trouble for about 12 years, I'm asking if the court would consider releasing him on pretrial release.
Your
All
Honor
right,
has,
what kind of history does Mr.?
and I'd ask pretrial if he has anything out of county, if you could, supplement, but as far as Broward, 2010 delivery of cannabis with a violation of probation in 2013, paraphernalia 08, theft 09, grand theft auto 05, cocaine 03, paraphernalia 02, theft 2000. That's fine if you, anything else that you have. Yeah, no,
I
if
don't,
any,
based on are you looking at the probable cause affidavit? Do you have it? Did he, well, per the allegations, it says that the display rack of potato chips was, removed, but then later on it's saying that it was put back, but was it put back in place without the potato chips?
No.
Or was the whole thing put back in place?
I think the whole thing was put back in place, Your Honor. Ultimately, and the allegation is, do you have the second page there?
I guess so then the allegation is $1,000?
$1,100 in cash was missing.
$1,100, okay.
I mean, really, the thing that kind of strikes me, it appears that these two men have known each other for 19 years.
Well, that's what the report says, so
Yeah, that's what-
that was
yeah.
my other question, that is what's going on here. All right. Does Mr. Johnson have an address?
He has a mailing address. It's a shelter that he stays at, Judge, that he can get correspondence at. But as far as like a regular apartment or something like that, no, Judge, he does not.
I don't know, Mr. Johnson knows the business, worked for the business owner
Judge, my understanding is that location is the type of gas station. He will not be returning there.
All right, I'll release Mr. Johnson to pretrial supervision. No return to this location. You cannot go back there, sir. Do you understand?
Listen, man. I will not. I will not.
You must go to the pretrial office by tomorrow morning and report. If you don't report, a warrant will be issued for your arrest.
Okay.
All right, good luck, sir. All right, Raymondo Alvarez.
And Mr. Alvarez, he's here present, Judge.
Good afternoon, Your Honor.
Good afternoon, Mr. Alvarez. Mr. Alvarez was arrested on May 31st. And it looks like he has $2,200 in bond.
That is correct, Judge. My understanding, Judge, he's 38 years old. He's been here his whole life. He is working. He works for a tree service where he's been there about 4 months. He's currently living in Miramar where he rents a room for about $110 a week. But he is going to be moving out and be residing in West Park. My understanding, Judge, is he does have prior contact with the criminal justice system, but it's been about over a year and a half. Judge, at this time, Judge, we're going to be asking, considering these are drug offenses, we're going to be asking the court to consider releasing Mr. Alvarez on pretrial release with random drug testing.
One moment, Judge.
Okay.
I'm fine with that, Judge.
All right, so Mr. Alvarez will be released to pretrial supervision. Sir, that's going to include random drug testing. You must report by 9 a.m. tomorrow morning to the pretrial office. If you don't,
Yes, ma'am.
a warrant will be issued for your arrest. Do you understand
I
that?
understand.
Okay,
I'll
sir.
cooperate.
All right. Robert Larkin.
He's approaching, Judge. Come on up, Mr. Larkin.
All right, Mr. Larkin was arrested on June 1st. He has a $1,000 bond on the possession of cocaine charge. Does Mr.
Judge,
Larkin, does he have
his-
criminal history?
Yes. He's got a pending possession of cocaine. He was arrested April 27th, ROR'd and released May 2nd. He may have other pending cases out of mental health court, including DWS habitual offender, possession of cocaine, possession of cocaine. Looks like he was placed on 3 years mental health probation in 2018.
Judge, and speaking of Mr. Larkin, I did advise him as far as when I looked in the system, I did see that case that he was out on 195426, but at magistrates, he was given a straight ROR. And I tried to talk to Mr. Larkin to see what actually happened on that day. He said there was, I believe, what his attorney was telling him, there was real problems with the PC affidavit. Judge, from what Mr. Larkin advised me, and I don't know the status of the case, I haven't had a conversation with the case filer, but that case should not be filed. But hold on, let me do the time. Having said that, Judge, he does have an address. He lives in Deerfield Beach, with his wife and kids. He's still here on $1,000 bonds. They can't afford to post his bond. He's asking, this case would, if the court would consider a pretrial release with random drug testing.
I don't understand. He was, what happened on the other case?
On 195426
That he was a
CF10A,
straight ROR?
I don't know. It happened. It came through over the weekend. I don't know why Judge McCarthy ROR'd him, but from what I can tell,
But
legally,
on which? On this case? Are we
on
talking about?
the possession of cocaine he's out
The
on.
other case that
Yes.
he's out on, okay.
Your Honor, he was seen hanging out in the rear of a business. He had active warrants. The officer arrested him on those active warrants. The officer is legally allowed to search him pursuant to that arrest, and at that point found a field-tested positive crack cocaine rock in his left front pocket.
Right.
I don't see a suppression issue, considering he had valid warrants at that time. So I don't know why he was ROR'd, but I don't see
Well,
any.
he was, on the other thing, and then he has got an open container that Judge McCarthy ROR'd him on, but then he had a $1,000 bond on the possession of cocaine charge.
I was speaking specifically to his April 27th
April
arrest.
27th, okay.
Yeah, he had warrants on his multiple cases out of mental health court. Officer searches him pursuant to executing that arrest warrant. Allegedly found a crack cocaine rock on him.
but my understanding, Judge, and what I believe, and Mr. Larkin is trying to explain to me,
That's been terminated.
Mr.
All have been
Larkin
terminated.
advised me that those were terminated, so therefore they weren't open at the time, and if they weren't open, Judge, he is saying he should have never been stopped for those warrants, hence he should have never been searched. I don't know if that led to the decision as far as having him straight ROR, but he was ROR'd on everything.
Everything.
And I'm not looking to
All
litigate.
right, so if we take it that he was ROR'd on everything, but then he's before the court again, so I'm leaving the bond at $1,000 in place, okay? LeCory Habersham. Bonded,
It works for me.
all right, and then Ms. Little was already handled, so,
Yes, ma'am.
all right, thank you, everyone.
Your Honor,
Yes,
please hold up Mr. Conti, Braxton,
where, which,
Conti facility.
who do we have?
Oh, yes.
Oh, that's right, I'm sorry.
Made a decision, and he's asked me to request the court to grant the motion for ROR. Is that right, sir?
Yes, sir.
What's his name again?
Mr. Bragdington.
Bragton.
Bragton.
Bragton,
Yes.
and he has nothing else holding him in custody?
He does.
He
He
does.
does?
That was the whole decision from the make. He
Right,
has,
but he wants the motion to be granted.
Yes, Judge, I explained to him that he would no longer be getting credit for time served on the charges that he's being released on. He has some violation of probation matters that he'll still need to straighten out.
Okay? And it is your decision, you want the motion to be granted, is that correct, sir?
Yes, ma'am, Ms. Powell.
All right, I'll sign the order granting the ROR. Good luck, sir.
Thank you.
All right. Thank you.
Thank you.